Hi, welcome to our channel of IGNOU audiobooks, Indira Gandhi National Open University, School of Law, SOL, Diploma. Postgraduate Diploma in Intellectual Property Rights, PGDIPR. MIP 103 Industrial Designs and Layout Designs of Integrated Circuits and Utility Models. Block-1 Industrial Designs. UNIT-1 Scope of Industrial Design Protection. 1.1 Introduction. What is design? The meaning of design is as follows. Design means only the shape, configuration, pattern, ornament, or composition of lines or colors applied to every article. The article may be in two-dimensional form or three-dimensional form or both forms. The application of the design to the article can be any industrial process or means. The industrial process or means may be manual, mechanical or chemical. The manual, mechanical or chemical process or means may be applied separately or combined together. The shape, configuration, pattern, ornament or composition of lines or colors in the finished article appeals to the eye only and judged solely by eye. Intellectual property, IP, refers to creations of the mind, inventions, literary and artistic works, and symbols, names, images, and designs used in commerce. IP is divided into two categories: industrial property, which includes inventions, patents, trademarks, industrial designs, and geographic indications of goods, and copyright, which includes literary and artistic works such as novels, poems and plays, films, musical works, artistic works such as drawings, paintings, photographs and sculptures, and architectural designs, and related rights, which include rights of performing artists in their performances, producers of phonograms in their recordings, and those of broadcasters in their radio and television programs. 1.2 Objectives. One of the important forms of intellectual property rights, IPRs, is industrial designs. After reading this unit, you should be able to define industrial design from the point of view of IP law. Understand the fundamental qualifying features of industrial design. Correlate the concept with simple examples. Appreciate the rationale for protection of industrial designs. Quantify the fundamental steps towards protection of industrial designs and its scope of protection. 1.3 Understanding industrial design. In our daily life, we generally refer an industrial design to products' overall form and function. In the context of intellectual property law, the definition of industrial design is as follows. An industrial design is that aspect of a useful article which is ornamental or aesthetic. It may consist of three-dimensional features such as the shape or surface of the article, or two-dimensional features such as patterns, lines or color. Industrial designs are applied to a wide variety of products of industry or handicraft. From watches, jewelry, fashion and other luxury items, to industrial and medical implements, from houseware, furniture and electrical appliances to vehicles and architectural structures, from practical goods and textile designs to leisure items, such as toys and pet accessories. According to the ICSID, International Council of Societies of Industrial Design, 3. Design is a creative activity whose aim is to establish the multifaceted qualities of objects, processes, services and their systems in whole life cycles. Therefore, design is the central factor of innovative humanization of technologies and the crucial factor of cultural and economic exchange. 1.4 Evolution of industrial design. The evolution process of industrial design is closely correlated with industrial growth and output. Historically, German leadership in creating industrial design as a profession is well appreciated. The United States leadership in industrial design was established after the World War II. With increased industrial output and capability, it is perceived that a tendency towards planned obsolescence was initiated to indicate industry's desire to produce consumer items that would be replaced even before their actual utility expired. Although the concept is often linked with the second half of the 20th century, it is likely that American industrialists saw this profit-making opportunity well before then. The scenario in UK. Importance of design in textile industries. Industrialization and methods of mass production paved way for the emergence of protection for industrial designs. The Designing and Printing of Linens, Cotton, Calicos and Muslins Act of 1787 of United Kingdom granted protection for a period of 2 months to every person who shall invent, design and print, or cause to be invented, designed and printed, and become the proprietor of any new and original pattern or patterns for printing linens, cottons, calicos or muslins. Recognition of design as a fundamental element of all production and manufacture. The Designs Act of 1842 extended protection to any new and original design, whether such design be applicable to the ornamenting of any article of manufacture, or of any substance, artificial or natural, or partly artificial and partly natural, and that whether such design be so applicable for the pattern, or for the shape or configuration, or for the ornament thereof, or for any two or more of such purposes, and by whatever means such design may be so applicable, whether by printing, or by painting, or by embroidery, or by weaving, or by sewing, or by modeling, or by casting, or by embossing, or by engraving, or by staining, or by any other means whatsoever, manual, mechanical, or chemical, separate or combined. Scenario in France. The law on literary and artistic property of 1793 was applied in certain cases to the protection of designs. The growth of the textile industries, in particular, soon led to the enactment in 1806 of a special law dealing with industrial designs. The law of 18 March 1806 established a special council, Conciliation Board or Conseil de Prud'hommes, in Lyon responsible for receiving deposits of designs and for regulating disputes between manufacturers concerning designs. While initially destined for industries in Lyon, particularly those manufacturing silk, the system of deposit and regulation by special council was extended to other cities and, through judicial interpretation, to 2- and 3-dimensional designs in all areas of industrial activity. 1.5 The formulation of a legal system for the protection of industrial designs. The rationale for a legal mechanism for protection for industrial design is based on the fundamental principle that intellectual property laws need to provide efficient and effective protection in order to promote human creativity and advancement of better designs to suit the needs of developing society. At the same time, there is the need for a balancing mechanism to ensure that the law does not unnecessarily extend protection beyond what is necessary to create the required incentive for design activity. The balance of interest is attained by defining the scope and boundaries of following fundamental concepts. The subject matter of protection of industrial designs. The most important point to understand is that the subject matter of the legal protection of industrial designs is not articles or products, but rather the design which is applied to or embodied in such articles or products. Most often, this is not understood. You may please note that the design protection does not apply to articles or products in such a way as to grant the proprietor of the design exclusive rights over the commercial exploitation of those articles or products. The design protection only applies to such articles or products as embody or reproduce the protected design. The conception or idea that constitutes the design may be something which can be expressed either two-dimensionally or three-dimensionally. For example, a fountain pen can have variety of shapes and colors which can be protected through industrial designs. The rights do not restrict any other manufacturer from producing or dealing in similar articles provided that such substitute articles do not embody or reproduce the protected design. Let us examine the following basic definition of design, which is used in the Registered Designs Act, 1949 of the United Kingdom. It refers to features of shape, configuration, pattern, or ornament. The Copyright, Designs and Patents Act 19885 of the United Kingdom also provides for a design right. Design is defined as referring to any aspect of the shape or configuration, whether internal or external, of the whole or part of an article. The design law of Japan refers to design as meaning the shape, pattern or color, or a combination of these in an article, and laws of France and Italy refer to both drawings or sketches, dessins two-dimensional, and models three-dimensional. If you carefully examine the definitions above, you will note that the approach adopted is similar and there is an emphasis of both two-dimensional and three-dimensional designs. In addition, you may also appreciate the fact that the definition of the words shape and configuration are synonymous. It is well applied in three-dimensional designs. Like, for example, shape of a mobile phone, the configuration of a wheelchair, etc. Similarly, the words pattern and ornament are also synonymous, and both refer to something embossed, engraved or placed upon an article for the purpose of its decoration or, in other words, to something essentially two-dimensional. Like for e.g., the floral patterns in a handkerchief or a carpet. Design law of Japan states that it extends protection to designs capable of being used in industrial manufacture. Industrial applicability is one of the important criteria for industrial design protection. Industrial design can be protected only if the design is capable of being used in the industry or in respect of articles produced in large scale. This is the essential difference between design and copyright. The subject matter of design protection, like shape, pattern, etc., is primarily an abstract concept. Therefore, one of the basic purposes of industrial design protection is the stimulation of the design element of production. It is, accordingly, a usual feature of industrial design laws that a design can be protected only if the design is capable of being used in industry or in respect of articles produced on a large scale. Article 25.1 of the TRIPS Agreement states that members of the WTO may provide that industrial design protection shall not extend to designs dictated essentially by technical or functional considerations. TRIPS provides international framework for IP protection laws. In most of the industrial design laws, you will notice that the functional aspects are excluded from the scope of industrial design registration protection. The rationale behind the exclusions of functional aspects from the scope of industrial design protection is to prevent a too broad scope of industrial design rights. For example, a screw is produced by a number of manufacturers, and all of them provide the same utilitarian function. The shape of screw can be novel and can qualify for industrial design protection. But if you extend it to the functional elements, it will exclude all manufacturers from producing similar products in the market. However, the patent law is one option which can be explored for protection of functional elements of the product provided it satisfies and qualifies the criteria of patentability. It is a requirement of all industrial design laws that protection through registration shall be granted only to designs which are novel or, as it is sometimes expressed, original. The novelty of the design constitutes the fundamental reason for the grant of a reward to the originator through protection by registration of the industrial design. The biggest challenge is to ascertain the novelty of the design. While deciding the novelty of a particular design, it is important to establish the fact that the design for which the registration is sought is absolutely new against all other designs produced anywhere in the world. The disclosure could be either in tangible forms like printed documents, literature, etc., or it can be oral means too. Though the rights conferred to a design is territorial, i.e., restricted to the jurisdiction in which the design registration is sought, the criteria are universal. Rights in industrial designs. The rights which are granted to the proprietor of a valid registered industrial design are intended to promote the fundamental basis of design law, i.e., to promote and protect the design component of the industrial product. While copyright confers on an author the exclusive right to prevent the copying of artistic or literary work, industrial design law grants exclusive rights to prevent any unauthorized exploitation of the registered design in industrial article. Entitlement to rights. The ownership of rights conferred by law in an industrial design vests with the creator, author, or originator of the industrial design. There are several questions raised on this point. First, who is entitled to legal protection in case of an industrial design that has been created by an employee? The answer is that the law usually provides that the entitlement to legal protection of the design shall belong the employer or to the person who has commissioned the design. The fundamental principle for this rule is that the creation of the design falls within the scope of duties of an employee. He/she are remunerated and therefore, the employee should seek the reward for his creative activity by means of incentives, salary, responsibility, and other conditions of employment. Acquisition of rights. Industrial design protection is granted in accordance with a formal procedure for the registration of such designs. Prior to registration, the most commonly adopted examination system stipulates a formal examination of the application for a registration of design. The fundamental principle governing examination system is to ensure that it satisfies all the criteria and formal requirements for an application which are governed by the relevant law. The most important question is how to ascertain the prior art and criterion of novelty or originality is satisfied by the design for which registration is sought. If the system follows only formal examination, then it is likely the onus of assessing novelty is shifted to those interested persons in the market who may wish to use, or who may have used the design or a substantially similar design. The alternative system of examination involves search of past designs and an examination of the design for which registration is sought to ensure whether it satisfies the criterion of novelty. It mandates the maintenance of a search databases and sufficient skilled manpower to undertake the substantive examination. What is relation to industrial designs to copyright? Key ponderable. It is argued that the objects, which can be granted protection under the law of industrial designs, might equally be well positioned to obtain protection from the law of copyright. To understand this concept, you must appreciate the fact that the industrial designs law has relations both with copyright law and with industrial property law. The question, therefore, is if a particular design embodies elements or features which are protected both by the copyright law and the industrial design law, can a creator of an industrial design claim cumulatively or simultaneously the protection of both laws? Cumulation of protection implies that the design is protected simultaneously and concurrently by both laws. This means the creator is entitled to invoke the protection of either or both the copyright law or the industrial design law. Therefore, if he has failed to obtain the protection of the industrial design law by failing to register his design, he can claim the protection of copyright law. It also means that after the term of protection of the registered design expires, the creator may still have the protection of the copyright law. The system of cumulation of protection by the industrial design law and the copyright law exists in France and in Germany. Coexistence of protection means that the creator has a choice. He may choose to be protected either by the industrial design law or by the copyright law. If he has chosen the one, he can no longer invoke the other. If he has registered the industrial design, at the expiration of such registration he can no longer claim protection under the copyright law, at least for the particular application of the industrial design. This system of coexistence of protection by both laws prevails in most countries, including India. Difference between copyright law and industrial design law. Copyright law. Copyright in most countries subsists without formalities. Registration is not necessary. Industrial design law. Protection is lost unless the industrial design is registered by the applicant before publication or public use anywhere or at least in the country where protection is claimed. Copyright law. Copyright is granted for a period for the life of author and 50 years after his death in most countries. Industrial design law. Industrial design rights are generally granted for a shorter period 3, 5, 10 or 15 years. Copyright law. Infringement only in the reproduction of the work in which copyright subsists. Industrial Design Law. Infringement whether or not there has been deliberate copying. There is infringement even though the infringer acted independently and without knowledge of the registered design. 1.6 Examples of industrial designs. Table 1 and Table 2 are examples of three-dimensional industrial designs. They are also comparative depictions and examples of ornamental and aesthetic changes that have occurred in products such as chairs, telephones, cars, computers, airplanes, TV cameras, etc. The iPod line came from Apple's Digital Hub category, when the company began creating software for the growing market of personal digital devices. Digital cameras, camcorders, and organizers had well-established mainstream markets, but the company found existing digital music players big and clunky or small and useless with user interfaces that were unbelievably awful, so Apple decided to develop its own. As ordered by CEO Steve Jobs, Apple's hardware engineering chief John Rubinstein assembled a team of engineers to design the iPod line, including hardware engineers Tony Fadell and Michael Dewey, and design engineer Jonathan Ive. The product was developed in less than 1 year and unveiled on 23 October 2001. Jobs announced it as a Mac-compatible product with a 5 GB hard drive that put 1,000 songs in your pocket. Source: www.apple.com. 1.7 Why protect industrial designs? Industrial designs represent one form of intellectual property. It is an output of human creativity and makes the product attractive and appealing. Further, it adds commercial value to the product and increases its marketability. When an industrial design is protected, it helps to ensure a fair return on investment. An effective system of protection also benefits consumers and the public at large by promoting fair competition and honest trade practices, encourages creativity, and thus leads to more aesthetically attractive and diversified products. Protecting industrial designs helps economic development by encouraging creativity in the industrial and manufacturing sectors and contributes to the expansion of commercial activities and the export of national products. So, industrial design protection benefits the owner, the consumer, and the economy in general. Another interesting feature of industrial designs is that they can be relatively simple and inexpensive to develop and protect. Therefore, they are reasonably accessible to small and medium-sized enterprises, even to individual artists and craftsmen, in both industrialized and developing countries. Benefits of industrial design protection: fair return on investment, fair competition and honest trade practices, more aesthetically diversified products. The basic objective is to protect new or original designs so created to be applied or applicable to particular article to be manufactured by industrial process or means. Sometimes purchase of articles for use is influenced not only by their practical efficiency but also by their appearance. The important purpose of design protection is to see that the artisan, creator, originator of a design having aesthetic look is not deprived of his bona fide reward by others applying it to their goods. 1.8 How can industrial designs be protected? Industrial design rights are intellectual property rights that make exclusive the visual design of objects that are not purely utilitarian. An industrial design consists of the creation of a shape, configuration or composition of pattern or color, or combination of pattern and color in three-dimensional forms containing aesthetic value. An industrial design can be a two- or three-dimensional pattern used to produce a product, industrial commodity or handicraft. Under the Hague Agreement concerning the International Deposit of Industrial Designs, a WIPO-administered treaty, and a procedure for an international registration exists. An applicant can file for a single international deposit with WIPO or with the national office in a country party to the treaty. The design will then be protected in as many member countries of the treaty as desired. In most countries, an industrial design must be registered in order to be protected under industrial design law. Article 25.1 of the TRIPS Agreement obliges members to provide for the protection of independently created industrial designs that are new or original. Members may provide that designs are not new or original if they do not significantly differ from known designs or combinations of known design features. Members may provide that such protection shall not extend to designs dictated essentially by technical or functional considerations. Article 25.2 contains a special provision aimed at taking into account the short life cycle and sheer number of new designs in the textile sector. Requirements for securing protection of such designs, in particular in regard to any cost, examination, or publication, must not unreasonably impair the opportunity to seek and obtain such protection. Members are free to meet this obligation through industrial design law or through copyright law. Article 26.1 requires members to grant the owner of a protected industrial design the right to prevent third parties not having the owner's consent from making, selling or importing articles bearing or embodying a design, which is a copy, or substantially a copy, of the protected design, when such acts are undertaken for commercial purposes. Article 26.2 allows members to provide limited exceptions to the protection of industrial designs, provided that such exceptions do not unreasonably conflict with the normal exploitation of protected industrial designs and do not unreasonably prejudice the legitimate interests of the owner of the protected design, taking account of the legitimate interests of third parties. The duration of protection available shall amount to at least 10 years, Article 26.3. The wording amount to allows the term to be divided into, for example, 2 periods of 5 years. India scenario. India's Designs Act, 2000 was enacted to consolidate and amend the law relating to protection of design and to comply with the Articles 25 and 26 of TRIPS Agreement. The new Act, the earlier Patents and Designs Act, 1911 was repealed by this Act, now defines design to mean only the features of shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, whether in 2 or 3-dimensional, or in both forms, by any industrial process or means, whether manual or mechanical or chemical, separate or combined, which in the finished article appeal to and are judged solely by the eye, but does not include any mode or principle of construction. India follows the system of first to file. Therefore, it is imperative that a rights holder applies for the registration of its design at the earliest opportunity to ensure that no other person can claim prior rights to the design. Furthermore, an application for design in India has to be filed before publication of the design in order to be eligible for registration. The Delhi High Court in Vimco Ltd Bombay v. Meena Match Industries, Shivkashi and others stated that publication within the meaning of the Act means the opposite of being kept secret. It is published if the design is no longer a secret. There is publication if the design has been disclosed to the public or the public has been put in possession of the design. It is not necessary that the design should have been actually used. There will just as much be publication if it is shown that it was known to the public without ever having been actually put in use. Thus, publication may be of 2 types. 1. Publication in prior documents. 2. Publication by prior user. Indonesia. In Indonesia, the protection of the right to industrial design shall be granted for 10 years commencing from the filing date, and there is not any renewal or annuity after the given period. Times the right to industrial design shall be granted for an industrial design that is novel new. Times an industrial design shall be deemed new if on the filing date, such industrial design is not the same as any previous disclosure. Times the previous disclosure as referred to in point 2 shall be one which before a. the filing date or b. the priority date, if the applicant is filed with priority right. c. has been announced or used in Indonesia or outside Indonesia. An industrial design shall not be deemed to have been announced if within the period of 6 months, at the latest before the filing date, such industrial design. Times has been displayed in a national or international exhibition in Indonesia or overseas that is official or deemed to be official, or Times has been used in Indonesia by the designer in an experiment for the purposes of education, research or development. Canada. Canada's Industrial Design Act affords 10 years of protection to industrial designs that are registered. There is no protection if the design is not registered. The Industrial Design Act defines design or industrial design to mean features of shape, configuration, pattern or ornament and any combination of those features that, in a finished article, appeal to and are judged solely by the eye. During the existence of an exclusive right, no person can make, import for the purpose of trade or business, or sell, rent or offer or expose for sale or rent, any article in respect of which the design is registered. The rule also applies to kits and substantial differences are in reference to previously published designs. Europe. Registered and unregistered community designs are available which provide a unitary right covering the European community. Protection for a registered community design is for up to 25 years, subject to the payment of renewal fees every 5 years. The unregistered community design lasts for 3 years after a design is made available to the public, and infringement only occurs if the protected design has been copied. United Kingdom. In addition to the design protection available under community designs, UK law provides its own national registered design right and an unregistered design right. The unregistered right, which exists automatically if the requirements are met, can medium black circle last for up to 15 years. The registered design right can last up to 25 years subject to the payment of maintenance fees. Japan. Article 1 of the Japanese design law states, this law was designed to protect and utilize designs and to encourage creation of designs in order to contribute to industrial development. The protection period in Japan is 20 years from the day of registration. United States. U.S. Design patents last 14 years from the date of grant and cover the ornamental aspects of utilitarian objects. Objects that lack a use beyond that conferred by their appearance or the information they convey may be covered by copyrighted form of intellectual property of much longer duration that exists as soon as a qualifying work is created. In some circumstances, rights may also be acquired in trade dress, but trade dress protection is akin to trademark rights and requires that the design have source significance or secondary meaning. It is useful only to prevent source misrepresentations. Trade dress protection cannot be used to prevent others from competing on the merits. Australia. In Australia, design patent registration lasts for 5 years, with an option to be extended once for an additional 5 years. For the patent to be granted, a formalities exam is needed. If infringement action is to be taken, the design needs to become certified, which involves a substantive examination. As a general rule, in order to be registered, the design must be new or original. Now, what constitutes novelty or originality may differ from country to country, and indeed the registration process itself varies from country to country. In particular, this can involve whether there is an examination or not as to the form and substance of the application for the registration of the design, especially to determine novelty or originality. An industrial design must be capable of being reproduced by industrial means, industrial application. Also, it must be possible to apply an industrial design to an article which may be either two-dimensional or three-dimensional. 1.9 Criteria for registration of industrial design. In most countries, an industrial design must be registered in order to be protected under industrial design law. As a general rule, in order to be registered, the design must be new or original. Now, what constitutes novelty or originality may differ from country to country, and indeed the registration process itself varies from country to country. In particular, this can involve whether there is an examination or not as to the form and substance of the application for the registration of the design, especially to determine novelty or originality. An industrial design must be capable of being reproduced by industrial means, industrial application. Also, it must be possible to apply an industrial design to an article which may be either two-dimensional or three-dimensional. Novelty. Originality. Industrial application. Depending on the particular national law and the kind of design, an industrial design may also be protected as a work of art under copyright law. In some countries, industrial design and copyright protection can exist concurrently. In other countries, they are mutually exclusive. Once the owner chooses one kind of protection, he can no longer invoke the other under certain circumstances. An industrial design may also be protectable under unfair competition law, although the conditions of protection and the rights and remedies ensured can be significantly different. 1.10 Proprietor of a new or original design. The proprietor 10 of a new or original design is as follows. Where the author of the design executes the work for some other person for good consideration, the person for whom the design is so executed is the proprietor of the new or original design. Where the person acquires the design or right to apply the design, the right being an exclusive right or otherwise, the person who acquires the design or the right to apply the design, exclusively or otherwise, is the proprietor of the new or original design. This right is only to the extent in and to which the design or right is so acquired. In any case, the term means the author of the design. Where the design has devolved from the original proprietor upon any other person, the term includes that person as well. 1.11 Duration of protection. Again, this varies from country to country, but the term of protection is typically for 5 years with the possibility of renewal, which may total, in most countries, up to a maximum of 15 to 25 years. The minimum duration under the TRIPS agreement is 10 years. In India, industrial designs are protected under the Designs Act, 2000. This will be discussed in detail in the next section. In other countries, depending on the particular law and the kind of design, a design may also be protected as a work of art under copyright law. In few other countries, industrial design and copyright protection can be cumulative. This means that these two kinds of protection can exist concurrently. However, in other countries, if copyright is allowed, it is exclusive to industrial design protection. This means that once the owner chooses one kind, he loses the protection of the other. Under some circumstances, and in some countries, an industrial design may also be protectable under unfair competition law. However, it is worth stressing that the protection and remedies are different under the different forms of protection. 1.12 Worldwide protection for an industrial design. As a general rule, and in accordance with the Paris Convention, industrial design protection is limited to the country where protection is sought and granted. If protection is desired in several countries, separate national applications or deposits must be made, and the procedures will normally be different in each country. However, the Hague Agreement concerning the international deposit of industrial design helps to facilitate this process. The Hague Agreement is discussed in detail in the next section. 1.13 What cannot be protected by industrial design rights? Designs that are generally barred from registration in many territories include designs that do not meet the requirements of novelty, originality, and/or individual character. Designs that are considered to be dictated exclusively by the technical function of a product. Such technical or functional design features may be protected, depending on the facts of each case, by other IP rights, e.g. patents, utility models, or trade secrets. Designs incorporating protected official symbols or emblems, such as the national flag. Designs which are considered to be contrary to public order or morality. Some countries exclude handicrafts from design protection, as industrial design law in these countries requires that the product to which an industrial design is applied is an article of manufacture or that it can be replicated by industrial means. 1.14 How extensive is industrial design protection? Generally, industrial design protection is limited to the country in which protection is granted. Under the Hague Agreement concerning the International Registration of Industrial Designs, a WIPO-administered treaty, a procedure for an international registration is offered. An applicant can file a single international application with WIPO. The applicant can designate as many contracting parties as he wishes. 1.15 Examples of industrial design protected through intellectual property rights. Look at the screen. 1.16 Understanding industrial designs in comparison with other forms of intellectual property rights. Difference between industrial designs and trademarks. An industrial design is distinguished from a trademark primarily because it is constituted by the appearance of a product, which must not necessarily be distinctive, a prime requirement for a trademark. A trademark, although it may consist of all kinds of visible signs, which may or may not be ornamental, must always be distinctive, since a trademark must always be capable of distinguishing the goods and services of one enterprise from another. Therefore, the functions of, and justifications for, protecting industrial designs and trademarks are quite different. Difference between an industrial design and a patent. The object of protection of an industrial design is different from that of a patent, primarily because an industrial design must relate to the appearance of the object, and which is not determined by technical or functional necessity. The object of patent protection, in contrast, is determined by the functionality of an object or process since it must be an invention. 1.17 Summary. An industrial design is that aspect of a useful article which is ornamental or aesthetic. It may consist of three-dimensional features such as the shape or surface of the article, or two-dimensional features such as patterns, lines or color. As with other forms of intellectual property, it may be protected. By protecting an industrial design, the owner is ensured an exclusive right against its unauthorized copying or imitation by third parties for a period of time, which is typically for 5 years with the possibility of renewal, up to a maximum of 15 to 25 years depending on the particular national law. The TRIPS provides for protection of a minimum of 10 years. In most countries, an industrial design must be registered in order to be protected under industrial design law, and as a general rule, in order to be registered, the design must be new or original. What constitutes its novelty or originality may differ from country to country, and indeed the registration process itself varies from country to country. In particular, this can involve whether there is an examination or not as to the form and substance of the application for the registration of the design, especially to determine novelty or originality. Thank you. Subscribe to our channel for more updates, and we will see you with the next chapter.